Welcome to Jackson Lewis's podcast, We Get Work. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every organization's mind: how will my business be impacted? From timekeeping technologies to dash cams, the Illinois Biometric Information Privacy Act, BIPA, is now being used to challenge a number and variety of time-saving programs and tools. On this episode of We Get Privacy for Work, we discuss the factors leading to the rise in BIPA cases. Today's hosts are co-leaders of the Privacy, AI, and Cybersecurity Group, Damon, Selvey, and Joe Lazzarotti, principals, respectively, in the New York City and Tampa offices of Jackson Lewis. They are joined by Jody Mason and Jason Selvey, principals in the Chicago office. Damon, Joe, Jody, and Jason, the question on everyone's mind today is, what BIPA compliance risks should you consider before adopting new technologies, and how will that impact my organization?
Thank you, Alicia. Welcome to the We Get Privacy podcast. I'm Joe Lazzarotti, and I'm joined by my co-host, Damon Silver. Damon and I co-lead the Privacy, Data, and Cybersecurity Group at Jackson Lewis, and in that role, we receive a variety of questions every day from our clients, all of which boil down to the core question of, how do we handle our data safely? In other words, how do we leverage all the great things data can do for our organizations without running headfirst into a wall of legal risk? And how can we manage that risk without unnecessarily hindering our business operations?
On each episode of the podcast, Joe and I talk through a common question that we're getting from our clients. And we talk it through in the same way that we would with our clients, meaning with a focus on the practical. What are the legal risks? What options are available to manage those risks? And what should we be mindful of from an execution perspective? Our question today is, what's going on with all this BIPA litigation? And to answer that question, we're bringing on two special guests, Jody Mason and Jason Selvey, who sit in the firm's Chicago office and spearhead our group's BIPA litigation practice. Jody, welcome to the podcast. And maybe to get us started, could you just share a little background about BIPA? Like, how did we get to where we are today with all of these claims?
I'm actually going to punt that one to Jason. Jason, if you want to give us some background and intro about the statute.
Sure. And first of all, thanks for having me. But how did we get here? Bad luck. Let's start with that. Let's say the Illinois legislature not doing us any favors. But no, really, the statute is actually, a number of years old, I guess 17 years old. But about 7 or so years ago, some enterprising plaintiffs' attorneys all of a sudden looked at the statutes and said, hey, this looks like a good statute to use. It's amenable to class actions. And all of a sudden, we were the envy of the nation with the tidal wave of class actions. There's been thousands of them. And, there's only been a couple that have gone to trial, but at the same time, it's been quite a few. And so that's how we are where we are today. And things are still developing even now. We can talk more about it, but there's still cases that are defining the law, defining what the covered data is, and we're still on the road here, so to speak. So I think that's how we got to where we are today.
Yeah, thanks, Jason. And while we're level setting for the audience, so that's a helpful recap of what BIP is, how the statute's evolved and been seized on by the plaintiff's bar. When we're talking about biometric information that is covered by the statute, what are we talking about? Could we get into some of the specifics around the types of data that might trigger the application of the law?
Yeah. So Damon, and again, thanks for having us today. BIPA actually regulates two different types of data, right? These are both terms of art under the statute, and it covers biometric identifiers and biometric information. And they sound similar, but they're actually two different things, right? Biometric identifiers are based on a body part, right? It's a retina or iris scan, fingerprint, voice print, or a scan of hand or face geometry. Biometric information is data that's derived from a biometric identifier regardless of how it's captured, converted, stored, or shared, used to identify an individual. And that's really the key part that we see a lot of litigation about, right? That used to identify an individual. What does that mean? Right? As you can imagine, there's been a fair amount of litigation over that issue. There continues to be a lot of litigation about what that means and about the terms themselves, right? The statute doesn't define voice print. The statute doesn't define a scan of hand or face geometry. So what does that mean, right? And the courts are still grappling with those issues. And we expect that that's going to continue to be the subject of litigation as these cases continue to progress.
So Jody, what kinds of use cases are you seeing that the litigation that you guys are handling is coming from? I imagine there's kind of a lot of similar types of uses of what generally referred to as biometric data information identified. But what are you guys seeing in terms of use cases?
Well, there's a lot of different types of technologies that are being targeted. I think in the employment context, right, cases brought by employees or temporary workers, by and large, the most prevalent type of case that we're seeing involves timekeeping technology, right? So a time clock that allows people to clock in or out by scanning a finger, a face, an eye, a hand. But that's certainly by no means the only types of cases that we see under the statute. We've seen litigation involving dash cam technology. We've seen cases involving point of sale systems, security access systems, right? So somebody's scanning a finger or a body part to access a part of a building, or a key storage system, or medication dispensing cabinet. There have been cases involving video game avatars, online photo storage, theme park entry. We've seen, vending machines, test-taking software, right? The plaintiff's bar has really tried to be creative and push the envelope in terms of the types of technology that they target. And as these technologies become more ubiquitous, right, it's been spurring more and more of this type of litigation.
So just one question on that. So I had to present at a conference a couple of days ago, and it was an interesting discussion. A lot of problems that some employers are having is, identifying remote IT workers who are trying to get these jobs fraudulently. One of the techniques is, can we, ask an applicant to show their driver's license to verify that that's who they say they are. I believe that Illinois statute may exclude photographs, but are you seeing any issues like that where, something that might be excluded could be included? Like, have you seen that kind of an issue come up where you use like a photograph or
Yeah, there's a fine line, right? Like I said, the scan of face geometry is not defined in the statute, right? We don't have a lot of guidance as to what that means. And yes, you are right that photographs are exempted from coverage under the statute. But the question becomes, when is something just a photograph? And when is something being done to the photograph to scan facial geometry? And that line is not always as clear as you might expect it to be. And it's been the subject of litigation, right? As to when is something covered and when is it exempted or outside the scope of the statute. So certainly something to be mindful of. We've seen a lot of litigation, for example, targeting financial services companies, where somebody provides perhaps a photo ID that is then compared against a live photo, or somebody's taking a selfie, right? Is this the same person in the driver's license as the person who's sitting here on the camera in front of me? That is something that has been targeted in litigation because, right, it's that act of comparing those two the photos that the plaintiff's bar has argued involves facial geometry scans.
Mm. So Jason, beyond the fact that various companies out there are using different types of biometric technologies for whether it's timekeeping or access control, including to vending machines. That's definitely one I was unaware of. What is it that these companies are doing wrong? Like, what are the core elements of the claims that are being brought under BIPA.
Right. And I'd say the first question is whether or not it's covered data, of course, but let's say that it is covered data under those circumstances. I mean, you've got the big three. The big three are what we see in almost all the cases. The first one is Section 15A, which I'm going to shorten it because it's kind of long and confusing, but it's having a retention and destruction policy for your covered biometric data. And you got to chuck it within the time that it's no longer needed, and or within in Illinois, within 3 years, whichever comes earlier. So that's a common one. And then the next one is the 15B, subsection 15B claim, which is really where it is. And that's the consent and information disclosure claim. And you have to get consent before collecting, taking, any of those. There's several terms for it within the BIPA to get knowing written consent. And also you have to make certain disclosures, such as how long you're going to take it, what are you going to use it for, and things like that. There's multiple requirements, and that is a thing that is easy to hone in on and easy to, at least in the past, to have issues with. And then the last one is the disclosure of the biometric data. And here, sometimes I think the plaintiffs are a little wishy-washy, don't know, what they might be alleging, but here it is. This is the most common thing is to your vendor, to somebody who's keeping that biometric data for you, and saying that, hey, you got to get consent for that too. It says it in the statute. And let's say that you don't. Then in that case, you've got another claim. Now, there's a couple others that are just not as common. For example, safeguarding the data appropriately. You'd think that might actually be common, but it would involve questions of fact. That's, for the plaintiffs, that's a little more complicated. Why get into that? But those are what we see most. And then the thing we really see that also is important is the damages under the statute and what's being requested. And this has actual damages. Let's throw those to the side because we're not aware of a single case under the BIPA where there has been any harm, where anyone had, their identity stolen, anything like that. So it goes to the statutory damages, which are $5,000 for a reckless or intentional violation and $1,000 for a negligent violation, plus attorney's fees, plus costs. So that's really where, and that's why the plaintiff's bar is interested, of course. And that's where, why they bring those claims in the first place.
Just a quick follow-up on that, Jason. So on the topic of consent specifically, are you finding that most defendants didn't get consent at all, or their consent was defective? What does the fact pattern typically look like?
Well, I think that depends on the era. When this first came down, back then, it was very common for someone to say, "What? What are you talking about?" And say that. But as time has gone by, I think Jody would agree. Companies have become more and more compliant. There are plenty of times now where we get a case and it's like, "Hey, buddy, hey, plaintiff's attorney, look at this," and they're out of there. But the kind of things you see though are often things that are like defective. I'm not going to say defective. I'm going to say less specific, perhaps, where you might see a claim based on that one we wouldn't agree with, but something like that. But these days there's a good number of companies that are really doing it, and it's easier to get examples from other companies to start with too.
Yeah, and Damon, on that, I think we also are seeing, as more and more companies have become compliant, courts are going to grapple with the question of a post-use consent and what is the effect of that, right? We don't have clear guidance from courts on what it means when a company gets consent after someone has been using a system for some period of time, but that's something that's going to be working its way through the courts as well.
So just to clarify, Jody, there are claims being brought saying that maybe as of June 1st of this year, you were getting compliant consent, but prior to that, you were not. And so we're making a claim based on the prior violations.
Yeah, the statute suggests, although it's not entirely clear, that a consent should be obtained prior to collection. So if there was not a consent in place prior to the first collection or disclosure of data, that's where we see a claim brought a lot of times.
And are you seeing that it's the case that when a company goes to remedy the fact that it either wasn't getting consent at all or the consent might not have been as specific as it could have been, that then prompts the bringing of claims because it puts this on people's radars?
It's certainly something that we do see periodically. So we always do recommend that companies work with counsel closely with respect to policies and consents.
Do you have any other kind of trends, Jody, that listeners may find interesting or helpful as they think about or implement different types of technologies that you're seeing in the litigation that might be helpful?
Yeah, I mean, BIPA continues to be the subject of a lot of litigation, including a lot of appellate review. We don't expect that to change. Two big issues right now they can talk about that are on the radar that we expect will be decided probably within the next year that are working their way through the courts. One is with respect to the scope of the healthcare exemption under BIPA. Right? So BIPA, when it expressly excludes from the definition of biometric identifiers and biometric information, information that is collected, used, or stored for healthcare treatment, payment, or operations under HIPAA. So the Illinois Supreme Court decided a case at the end of 2023 called Mosby versus Ingalls Memorial Hospital. And in that case, it involved healthcare workers that were scanning their fingers to access a medication dispensing cabinet. And the Illinois Supreme Court said, well, any collection of data in connection with that medication dispensing cabinet falls within the scope of that healthcare exemption, and so it's just excluded from coverage under the statute. So the big question that the courts are now grappling with are, what happens when it involves a timekeeping system used by healthcare workers, right? Is data generated from that type of system, can that be excluded from the scope of the statute as well? And that issue is currently up on appellate review. And, so we're watching that issue closely. The other issue that we're seeing that's been a big subject of attention from the courts over the past year is the effect of a clarification to the statute that was enacted by the Illinois General Assembly about a year ago in August of 2024 in response to the Illinois Supreme Court's decision in the Cothron versus White Castle case. And in the Illinois General Assembly essentially said that when the same entity collects the same biometric identifier or information from the same individual using the same mechanism of collection, that at most, that's a single violation of the statute for which there can be, again, at most one recovery. And the real big question right now is, does that clarification legislation apply to cases that were pending at the time that it was enacted? Or does it only apply prospectively to future cases? And obviously, that will have a potentially very large impact on cases that are pending, because it could take off the table the possibility of what we call per scan damages. So we're watching, the federal appellate court for the Seventh Circuit has recently decided to take that issue up. So we're all waiting to see what happens with that issue.
Jason, would you mind just at a very high level for those who maybe haven't had the pleasure of going through one of these cases, just take us through what they look like, starting from the filing. Is there usually multiple filings by different plaintiffs' firms, or it's just one filing, and then we usually make a motion to dismiss, or do we answer? Like, what does the case usually look like? How does it play out?
Sure, Damon. And I'll say this, maybe in the earlier days, we saw more, two quick filings for the same thing. We don't see that as much anymore, but it's really just usually one filing brought by, and this is the interesting, maybe not interesting, but there's like 10 firms that bring like all of these, which maybe you're not going to be so surprised by. But we get the complaint in, and I have never been in an area of law where it has been such a chance to be creative, where we do everything from filing a demand for a bill of particulars just to slow them down and say, hey, give us all this information about your damages claim and so forth, moving to dismiss on, just these great grounds, the different ones, like like railway preemption, even though it's it may be a railroad, an airline or something like that, knocking people out because they're union members. So, at a high level, we fight and fight, which we wear them out. We stay cases when it makes sense, and we can do so. And in the end, where do these end? Well, I mean, most do end in settlement, but not always. You can win that motion to dismiss sometimes, and that of course is a good feeling. But like I said, only a couple have gone to trial, so that's really the way that they go.
Are you seeing any that go to a summary judgment motion, or is it typically either we win on a motion to dismiss or resolve certain discovery?
Here's why. It's not usually that we're afraid to, it's that we're so busy slowing things down and making sure that we, get a good result. But I have filed motions for summary judgment before, and they do happen, certainly. But, at the same time, some of the things that we're bringing defenses about, it may not look very different at summary judgment. For example, like, is this consent good enough? I mean, yeah, you could find later evidence maybe, and at summary judgment will be different, but it may be exactly the same. So that's the other sort of thing. But we do get there, and we do get to other motion practice, certainly, along the way.
So have you guys seen any developments in other states that are raising any similar types of claims at this point?
Yeah, I mean, the one that's just like BIPA, or maybe not just like BIPA, but quite a bit, is Texas. And it's also a little older. I don't remember the year. But just the biggest difference between Texas and Illinois is when I said that it has to be destroyed, the data has to be destroyed within the time it's not needed, essentially, or 3 years, whichever is earlier. It's 1 year in Texas. Washington also has a one that's more about commercial use for commercial purposes data. But two key things about this and the other ones I might mention is that there's no private right of action. That's why you haven't had a massive, movement of plaintiffs' attorneys to Texas or to Washington. But one of the big ones is Colorado. Just enacted a law on July 1st of this year that deals with biometric information as well, and it uses some of the same words as BIPA, some not. But an important thing is that it does allow requiring as a condition of employment that employees give you permission to use their biometrics for a discrete number of purposes. Now, for us, the one we see most often is on that list, which is timekeeping. But not everything we see is on there. And also, there's some other requirements. They're like, also, you have to have I believe it's a crisis response plan, and also something else I'm just not remembering right now. But there are a couple others too, and we've seen for I think years New York toying with doing one itself. But that's it for now. But I'm sure we'll see more as time goes on.
Yeah, Jody, maybe to help us land this plane and wrap up, could you talk a little bit about what companies can do to get out in front of these claims and put themselves in a better position?
Yeah, I think the first thing, Damon, that I would recommend that companies do is really just take stock of the technologies that they're using, right? To be aware of whether or not any of the technologies implemented company-wide could potentially implicate BIPA or similar statutes in the states in which the company operates. And even if a company has a policy and consent in place, I think it's really a good idea to have a periodic review of those policies and consents with counsel, because we, as Jason mentioned, we're seeing new laws enacted. We're seeing the case law continue to develop. We're seeing, how the plaintiffs are bringing these types of claims and how they're framing the issues. And so it's just a good idea to periodically, have those policies and consents reviewed. And, once you have those policies and consents in place, you do a periodic review of them, then looking at what you're doing to implement those policies and making sure that you're doing what you say that you're going to do, that you're following the policies, that you're getting the consents that you need to be getting. right? Because you can have the greatest policies in the world in place, but if you're not following them, right, you could still have a potential issue. Certainly, if you operate in Colorado, you want to make sure to update your policies to account for that new statute that's in place. And, this is the big one. I would say, in a perfect world, if a company can have a process in place for the review of new technologies before they're implemented, right? That's really key, right? To have legal review, either with inside or outside counsel, to say, hey, this is what we're thinking of using or implementing. Here's where we're thinking of implementing this technology and how we're planning to use it. Does it implicate BIPA or any other potential privacy laws, right, in the states where we're using it? And what do we need to do to get compliant, ideally before that technology is implemented? And if you do those things, knock on wood, you will stay out of the crosshairs of the plaintiff's bar.
All right. Well, thank you guys so much for coming on. This has really been helpful. I think for us and for everyone. Damon, it's always a pleasure presenting with you. And if anyone has any questions or suggestions, feel free to reach out to us at privacy@jacksonlewis.com, privacy@jacksonlewis.com. And again, thanks for everyone. Have a great weekend.
Thanks for having us.
Thanks for having us.
Everyone.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com.